Mr. O'Brien's recitation is accurate, I would only distinguish the fact that the order is not assigned to a hearing examiner. The hearing examiner is only for the purpose of considering motions or petitions to intervene. I know that was a mere oversight. We have circulated the order with Chesapeake's counsel and with the Public Advocate's Office, and we would recommend the Commission's approval of Order 9272.
Thank you very much. Any questions from the Commissioners? You weren't here last time. That's how.
But I'm here today.
Okay.
The Public Advocate has had an opportunity to review the proposed form of order and recommends it for the Commission's approval. Thank you.
Thank you.
In drafting this, it has been reviewed by the parties, and the comments are included. As in the last matter, which you considered, the hearing examiner has been appointed for the purpose of considering petitions for intervention. Staff has no additional comments to the order and recommends your favorable approval of it. Thank you.
Thank you. Ms. Iori.
Thank you, Madam Acting Chair and Commissioners. The DPA has nothing to add to what you've already heard.
Commissioners, do you have any questions? Commissioner Gray?
Madam Chair, I move that the Commission adopt Order Number 9273 as submitted.
I second it.
Any questions on the motion? All those in favor, please signify by saying aye.
Aye.
Any opposed? Any abstentions? All right, item number 3 on the regular agenda is in the matter of the application of Delmarva Power and Light Company for an annual update in the gas environmental surcharge rider rate.
Thank you,
Ms.
Madam.
Orr.
Thank you, Madam Acting Chair. Delmarva also filed its application to change its environmental surcharge rider rate on August 24th, 2018. And again, Delmarva thanks staff for preparing the opening order for this docket and for the opportunity to comment. As with the previous item, Delmarva's comments to the order have already been incorporated in the version in front of you today. Order number 9274 will open the docket for this proceeding and permit Delmarva's proposed decrease in the ESR rate to become effective for gas usage on and after November 1st, 2018, with proration and subject to refund pending further review and final decision by the Commission. Accordingly, Delmarva respectfully requests that the Commission enter Order number 9274, opening the docket for the ESR. Thank you.
Thank you. Mr. Willard.
Yes, what Ms. Orr said is exactly right. This petition seeks to decrease the amount of the ESR rate. And there will be an evidentiary hearing on November 8th in front of the Commission, and public notice will be issued. Objections must be filed by October 18th, and petitions intervened by October 11th. And we also urge you to approve Order number 9274.
Thank you. Ms. Iori.
Thank you, Madam Acting Chair and Commissioners. The DPA has nothing to add to what you've already heard.
Thank you very much. Any questions from the Commissioners? Do Do we have a motion?
I move that we approve order number 9274 as presented.
Second.
Second.
Any questions on the motion? All those in favor, please signify by saying aye.
Aye.
Any abstentions? Any opposed? Thank you very much. Item number 4 is, in the matter of the application of Silver Run Electric LLC for a certificate of public convenience and necessity to begin business as an electric transmission utility authorized to provide transmission facilities in Delaware. I believe Mr. Walsh is our lead on this one.
Yes, thank you, Madam Acting Chair. This is staff's order requesting an additional 90 days to act on the application of Silver Run, which filed on July 3rd an application for CPCN to become an electric broker in Delaware. And one of the criteria for granting CPCN is for staff to consider the impact of granting that application, the impact on the state's economy, benefits to state ratepayers. At this time, the cost allocation of the subject project is before FERC. Proceedings are pending. And in light of that, staff is asking for an additional 90 days on which to act on the application. And that is in accordance with Section 3011-2.2.28, the regs which allow the extension for an additional 90 days. We have circulated the proposed order with Silver Run's counsel as well as the DPA. And with that, we would request that the commission approve Order 9275 and grant the additional 90 days.
Thank you very much. Is there anyone here representing Silver Run Electric? There being none, Ms. Iori, do you have any?
Yes, thank you, Madam Acting Chair and Commissioners. The DPA requests that you approve this proposed form of order, which postpones a decision on the CPCN pending, for 90 days. Hopefully, by then, FERC will have issued an order deciding on what cost allocation methodology it will accept for the project. Thank you.
Thank you very much. Commissioners, any questions?
Madam Chair, I move that the commission adopt order number 9275 as submitted.
I second it.
Any questions on the motion? All those in favor, please signify by saying aye.
Aye.
Aye. Any opposed? Any abstentions? On to item number 5. In the matter of provision of standard offer supply to retail consumers in the service territory of Delmarva Power and Light Company.
Good afternoon,
Mr. Goodman.
Madam Acting Chair, Commissioners. Todd Goodman on behalf of Delmarva. You see us before you on this matter about once a year, and staff explained it very well in their memorandum, but we do a stakeholder process we call the SOS Procurement Improvement Process. And now in modern times, we're doing it by webinar, which is nice. We used to try and cram everyone in a room. And we go over proposed changes to what are still called FSAs, full service agreements, although they're not full anymore because the suppliers don't provide the REC compliance anymore. That's done directly, or the RPS, sorry, compliance. That's done directly by Delmarva now pursuant to some statutory changes that happened around you and us over the years. But, you know, there were no opposition raised or concerns raised by any of the suppliers who participated. We make these changes just to keep the contracts for SOS Supply current, best protections, reasonable protections for our customers. Staff has done its normal job of reviewing them, and in their well-written memorandum, they have no objections. So we just ask that you approve these small tweaks to the SOS contracts so we can do our auction and hopefully continue this long run of really favorable energy prices for our customers who are on SLS.
Thank you very much. Mr. Willard?
Yes. What Mr. Goodman said is correct. I would just point out, the commission back in 2005 originally approved a process. In 2008, you approved a reverse auction process. And now the company has come in with some further changes to the process. And I think there were 6 exhibits attached that explain everything that the company wants. And the staff is in favor of this and asks you to approve order number 9276.
Thank you very much. Ms. Iori?
Thank you, Madam Acting Chair and Commissioners. The DPA agrees with the staff's memorandum and the proposed form of order and requests that you approve it. Thank you.
Are there any questions from the commissioners? May I have a motion?
I move that we adopt order number 9276.
I second.
Any questions on the motion? All those in favor, please signify by saying aye.
Aye.
Any opposed? Any abstentions? Thank you very much. Motion carries.
Thank you.
Item number 6 on the agenda. In the matter of the petition of the Public Advocate of the State of Delaware for an order requiring Delmarva Power and Light Company to amend its certification of medical need form pursuant to 26 Delaware Code subsection 117D and to change the language in the denial letter it sends to rejected applicants for certifications of medical need. I believe, Mr. Slater, you're going to start this off.
Yes, thank you, Madam Acting Chair and Commissioners. Today is Tuesday, September 25th. This should be a rather simple and straightforward petition. The law is clear. It's in front of you now, and with your indulgence, I'm going to read it to you. Section 117D of Title 26 says, in no event shall such termination occur if an occupant of a dwelling unit shall be so ill that the termination of such sale or service shall adversely affect his or her health or recovery, which has been so certified by a signed statement from any duly licensed physician, physician assistant, or advanced nurse practitioner of this state or of a state with similar accreditation and received by any employee or officer of such person engaging in the distribution or sale of gas, electric, water, or electricity. Signed statements from a licensed physician, physician assistant, or advanced nurse practitioner obtained pursuant to this section are effective for 120 days. Signed statements may be renewed by means of a new signed statement to prevent termination only if a customer makes a good faith effort to make payments towards the utility service being provided. The Delaware Public Service Commission may promulgate regulations defining good faith effort to make payments. If a utility is subject to the jurisdiction of the Delaware Public Service Commission, the utility or the customer of the utility may petition the Public Service Commission for review of any dispute under this section. While such dispute is pending, a utility shall continue to provide utility service to the customer until a final commission adjudication of the petition is issued. When possible, no termination under this section shall occur without advance notice to any known case manager or coordinator of an occupant in an affected dwelling unit. Section 117E states violation of this section shall constitute a misdemeanor. That's the end of that section. You're no doubt wondering why we even have to bring this decision today, because the law is clear. But let me tell you, I've tried to resolve this petition for the past 6 weeks or 47 days. It was only yesterday at 11:39 p.m. that Delmarva decided to respond, and that was because of our petition. So here's the timeline. I first sent an email to Delmarva on August 10th at 1:25 p.m. ahead of our August 13th meeting, providing a list of issues we wanted to discuss, and in short, Delmarva was prepared to discuss these issues and didn't feel, quote, sandbagged. In the meeting was their CSR director, I believe that's her title, Regulatory Strategy and Services Director, and Regulatory Policy and Strategy Vice President, among at least one other. That's a lot of directors who one would think could get something done when we raise the issue that Delmarva does not seem to be complying with state law regarding medical certification and disconnections. In that email, again on August 10th at 1:25 p.m., I list several, actually 11, issues that had come to light in the past few weeks that we wanted to discuss. They were definition of usage, voice approval to assume bills, not hearing back from CSRs or Delmarva Power, medical certification form, theft of service, AMI meters, capping on collectibles, definition of good faith payment, communications in general, hard-keyed spreadsheets, and inconsistencies in letting some balances accrue while others were disconnected quickly. In addition, I said, we can, and I quote, "We cannot miss this opportunity to speak with you about concerns we've seen recently before action is taken." Again, this was on August 10th. As you'll note, one of the items listed was the medical certification form. On August 27th at 7:57 a.m., 14 days after our initial meeting and 17 days after issues were listed to be discussed, Delmarva wrote back regarding 4 of those 11 issues. Regarding the medical form, they said medical form, and then in parentheses, reference to CPAP and BiPAP, and parentheses, legal is reviewing. That's on August 27th, which was almost 30 days ago, so legal's been reviewing for at least that long. We followed up on August 30th at 3:54 p.m. asking about the other issues that were discussed. That was 26 days ago. We haven't heard back. On September 17th, after hearing nothing from Delmarva for 21 days, we filed this petition. Before the petition was filed, I personally called Delmarva twice that morning and left a voicemail, and followed up by email at 12:11 p.m. stating our intention and promising to send along the petition as soon as it was finalized. In addition, I reached out to Dr. Barua, providing him the same notification. On September 17th at 4:02 p.m., we submitted an email to the parties with our petition attached. Again, that was after waiting 21 days from when legal is reviewing and 35 days from our meeting to discuss this issue. On September 19th at 1:55 p.m., Delmarva called me and followed up to my outreach earlier that day. In that conversation, Delmarva said that they were going to ask for more time because the petition would be, before the petition would be heard, because of all the levels they have to go through. Again, Delmarva's legal has been reviewing this at that point for 21 days. I understandably pushed back on that thought because the law was clear and we're trying to protect customers, and that we had met on August 13th and discussed these issues after we sent Delmarva the topics to discuss on August 10th. Their response, they said one meeting wasn't enough. One meeting, 6 weeks, or 43 days, or 3,715,200 seconds, or 61,920 minutes, or 1,032 hours, or 11.78% of an entire year that we made Delmarva aware that this form did not comport with state law, which by law is a misdemeanor offense. Today at 11:18 a.m., I received an email from the Regulatory Strategy and Services Director stating, "Your petition forced an immediate response from the company," and then goes on to say, "The company's position, which agrees with some of your requests, is the company's good faith effort to respond to the issues that you've raised." I raised these issues on August 10th. We met on August 17th. Legal's been reviewing since August 27th. And we filed our petition on September 17th after Delmarva's inaction. The email goes on to say, as a general matter, we're quite responsive to your office and communicate with you on a regular basis on a host of issues. Obviously, this issue moves slower than your expectations, but a phone call or email to me concerning its urgency could have resolved that. Delmarva cannot seem to comprehend the urgency to this matter that we brought up and suggests, as they often do, putting blame on anyone else, specifically in this case me, or my office, and that's astonishing. The DPA brought this up on August 10th, met on August 13th. You're going to hear that quite a few times. Delmarva responded, legal is reviewing on August 27th. We followed up about the other issues that haven't been addressed on August 30th. We filed a petition on August 17th, only after calling Delmarva and leaving, not August 17th, September 17th. Only after leaving voicemails and emails, we tried to do our due diligence to alert them that this was coming. Delmarva calls me back on the 19th, saying that they need more time. They respond to our petition at 11:39 a.m. on September 24th. And today I received the email placing the blame on me. This issue we wanted fixed because Delmarva customers called our office regarding not filling out the form because they had a CPAP machine, and the form bolded a section to say does not include small volume nebulizers or CPAP BiPAP machines. That person who was failed by the system was shut off for failure to pay because the form specifically said doesn't include small volume nebulizers or CPAP BiPAP machines. Sorry. include, specifically said, does not include small volume nebulizers or CPAP, BiPAP machines. I'll get you a copy of this too, sorry. I always tend to do that. Meanwhile, someone else had over 11 installment plans, multiple agency holds, and 42 return checks since 2017. That was last year. Owing more than $10,000. They still had power. And yet another person was threatened with a disconnect for failing to pay $450. There was no rhyme or reason to the subjective determination of disconnections, one of the issues we asked about on August 13th. We still haven't heard back on that issue. The person who didn't fill out the form because of its language, all of us, failed them. And we continue to fail them unless we approve this petition today. Now, Delmarva at 11:39 a.m. yesterday said, ironically in bold, as long as the customer submits a complete medical certification form signed by an appropriate medical professional, Delmarva will grant them a medical certification even if the type of equipment listed is a small volume nebulizer or CPAP, BiPAP machine. This even if cuts to the heart of the issue. Delmarva is subjectively determining who receives a medical certification, which they have no right to do under the current law. Even if is not a favor to me or the customers or to you, the examples and subsequent questions asking why a form is needed are irrelevant. That's for a medical professional to decide. Delmarva is not a medical office, nor do they have medical professionals reviewing these forms. They went on to say that CPAP, BiPAP customers take the most advantage of the system in not paying their bills. Again, this is where good faith effort to make payments was designed to alleviate this problem. Unfortunately, this commission had decided not to define this term in docket 16-0295 because you felt the utilities had proper procedures in place to make this determination. Apparently they're not, or at least not in the case of Delmarva. If Delmarva ever had such procedures, it's clear that they no longer exist. It should be noted that the only utility with large arrearages is Delmarva Power. No other utility had this problem, and that was part of the commission's determination in docket 16-0295. One more issue with what Delmarva sent yesterday. They said it's also important to note that Delmarva uses the information it obtains from these forms for a variety of purposes. It's for the customer's protection that we know what medical equipment customers have in their homes. Again, we're not using this information to assess whether a customer qualifies for certification. As long as they submit a complete signed form, they will receive certification. That's nice to say, but it's wildly inaccurate. Again, Delmarva has no right to subjectively select which medical reasons or certifications are more important. Let me tell you something. These people, again, have been failed because of the language of this current medical form. And the thought that Delmarva somehow has some way in determining what to accept is an astonishing problem. In case you weren't aware, a CPAP machine helps to regulate your breathing at night. I have some experience with this where someone stops breathing more than 100 times in a night. Imagine if this happened to you or your electric was shut off because Delmarva's determination, which is not based in any law, and in fact is the opposite in law. I'd be pretty frustrated and broken down too. And let me tell you, I know this customer and I've kept his name out of it, but I have those voicemails and it's heartbreaking. In fact, the Delmarva CSR told me they denied a medical form because the CPAP can be run on battery. Again, not their right to make that determination, but another subjective comment because of the examples and questions in the form. As long as good faith effort to pay is met, which isn't defined by anyone, that's the end of it. On August 6th at 11:11 a.m., I sent an email to Delmarva CSRs about an account who was on oxygen 24 hours a day, and they only had $400 to make a payment to Delmarva. Their doctor submitted a medical form on July 11th by fax, which they have confirmation of, but Delmarva said they never received it. An occupant of the home hand-delivered the medical certification form on Friday, August 3rd, and called our office because they were concerned that Delmarva was going to disconnect their service because they had said before that they hadn't received the fax, which we found all too common. Delmarva CSR responded the customer was enrolled in the medical certification program from February to June, and I left the dates out on purpose, but I can give them to you if you want. The customer was sent a recertification form, however, and it was received and reviewed by the company. The customer was advised the medical certification form was denied due to good faith efforts not being met. The customer paid $100 in 120 days. Good faith efforts to pay is not defined in any law or regulation or by Delmarva Power itself. I followed up twice before getting a response on August 10th stating that the customer would be re-enrolled in the medical certification program. After I pointed out the subjective nature of Delmarva's decision to disconnect this person who is on oxygen for good faith effort to make payments not being met, they said there are other factors to be taken into consideration such as payment history, account balance, account status, etc. I do apologize that at this time I'm unable to provide you a blanket definition. I assure you this topic will be further reviewed internally. Ironically, that was on August 10th at 2:38 p.m., or more than 6 weeks ago. They don't have the ability to make that determination. This has been made by them by the certified provider's signature. The subjectivity needs to be taken out of Delmarva's hands. Or imagine the Delmarva customer who calls me and tells me that she was told by Delmarva that she couldn't apply for a medical certification. I had that issue on September 5th and immediately followed up with Delmarva asking for a full accounting of her account and the phone records to review and see if that was indeed said. That's a pretty serious accusation that I didn't take lightly, and I don't think anybody else should. A week later, on September 12th at 1:40 p.m., I received an email from the CSR director. Again, I believe that's her title. That's a pretty high-up person responding to my request, and this is the bullet point listed that I received. Miss Doe, I changed her name, called asking for a medical form for her daughter's breathing. Her last payment was May 2018. The CSR explained the emergency medical equipment program and how advanced outage notification works when customers are enrolled. Ms. Doe says she was told it would help her, this being the medical form, and we would quote work with her a little bit more, end quote. CSR advised that that was not his understanding, but he would send her the form. Ms. Doe asked if it would work to give her more time, and the CSR advised her no, it would not extend the disconnect on her account. Again, the law is clear. Ms. Doe declined the form, became agitated and argumentative with the CSR. I can't really blame them. And the CSR, they say, was professional and pleasant throughout the call. The law states, in no event shall such termination occur if an occupant or any dwelling unit shall be so ill that the termination of such sale or service adversely affect his or her health or recovery. The CSR said it wouldn't stop or extend a disconnect. That's ridiculous. Read the law. The customer had a signed note from a medical provider. If the CSR had acted accordingly, that person would have been able to receive a medical certification form. Their doctor could have filled it out. Fortunately for them, they were able to come up with the money to keep the service on and assist the occupant of their home. But what happens when they can't find the money? I followed up that same day, September 12th, thanking the CSR director for the email, but again stating that my request was for the phone records. It was a serious accusation, and I wanted to confirm that myself so I could get back to the customer who had specifically called me. On September 20th, after my third request, the CSR director states, and I quote, "I have forwarded your request for a copy of this call to the legal department for review," end quote. Stymied again by legal is reviewing. This issue must be heard today and cannot be delayed. The public health of Delmarva's current and future medical certification customers is at stake. This is a public health problem. I can't sit back and let Delmarva or this commission not act and follow the law with this issue. Section 117D is clear. Delmarva's medical certification is at best wrong. Delmarva doesn't have the right to ask why a certification is needed. They only need to see that a certified person signed the form. If you leave that information in the form, you're allowing Delmarva to collect more information than is necessary to provide a medical certification form. Delmarva Power has no right to ask these questions. By removing the examples and subsequent questions, you're making the utility comport with law, assisting in the goal that someone doesn't get hurt, and remove all subjective reasoning from Delmarva's hands, because they don't have a right to make such determinations. It should be noted that not a single example relates to appliances that may be necessary, such as the need for refrigeration in the case of insulin or other important considerations. The two questions after the list of example are name of medical equipment in use. Please list all, if more than one, and if no equipment, please list medical condition requiring electric or gas and give a brief explanation why. These questions and the examples before them are irrelevant. Delmarva Power does not have the right under the law under the laws of Delaware to ask such questions, a licensed physician, physician assistant, or advanced nurse practitioner has already certified this need. Nowhere did the legislature or the governor state that the utility was able to make a determination as to whether special circumstances are present. Again, the law states licensed physician, physician assistant, or advanced nurse practitioner. We can agree or disagree, but it is the law, and we must comply with the law. Again, the law, I'm not going to read the law again, but I think I've made that point pretty clear. It does not allow Delmarva or any other utility to make any other determination. Section 117E states that this is a violation of the section should constitute a misdemeanor, and surely this commission can see that this issue can't be punted to a future meeting. There is clear and present danger to Delmarva's customers' health and well-being by not requiring the forms be changed immediately, thereby removing any subjective nature by Delmarva. And it's also for Delmarva's own protection. The second part of our petition was relating to the denial form, which we noticed from customer calls needed a change in wording. This was done to us having received calls about the term contest and calling the commission staff, who understandably didn't know why a medical form was denied, would have to follow up with Delmarva anyway. So this made it conform more with the commission's rules of practice and procedures, and suggested that an inquiry be made with the PSC staff. Finally, you're welcome. This commission should approve our petition and order Delmarva's forms changed, requiring the new forms be used immediately. Again, we discussed this issue with Delmarva Power 6 weeks ago. That's 43 days, 3,715,200 seconds, 61,920 minutes, 1,032 hours, or 11.78% of an entire year that we gave Delmarva to respond to our request to change the medical certification form. It should have been enough that we brought this issue up once and asked that it be changed. Remember, they had the CSR director, the regulatory affairs director, and a vice president for regulatory affairs in the meeting. If the commission declines to address this issue today, I have to object, as any such decision is a clear detriment to the health of current and future Delmarva Power medical certification customers. And it doesn't sit well that if we can't correct this at best error today, as I've already stated, this issue was known since August 13th and legal what is reviewing since August 27th. We need to protect the health of Delmarva Power customers, and it's up to you to do that today, and not punt this issue to October 9th, which would allow Delmarva Power 57 days, 8 weeks, 4,924,800 seconds, 82,080 minutes, 1,367 hours, or 15.62% of an entire year, to address our concerns that they were not complying with the state law. I think we've been more than reasonable in bringing this issue up 6 weeks before we filed our petition. It's time to protect Delmarva's ratepayers. I want to make one more note that I got their proposed form of order at 12:54 right before this meeting today. And again, it highlights the problems and not comporting with the law already. On the second page, the second whereas, it says, whereas Delmarva uses the examples of the types of medical equipment for which electricity or natural gas is medically necessary to discourage individuals who do not truly depend on electricity or natural gas for their health or recovery from taking advantage of the medical certification program as a way to avoid paying for their usage, which increases uncollectibles for all ratepayers. Again, they use this to discourage individuals who do not truly depend on electric or natural gas. I'm not going to have to read the law over to you. I would prefer not to, but they have no right to discourage individuals. The entire right lies with the licensed physician, physician assistant, or advanced nurse practitioner, of which I know of no one in Delmarva who qualifies. And then the fourth whereas on the second page says, whereas Delmarva does not use this type of medical equipment or medical condition listed on the certification to exclude individuals from receiving medical certifications, and then it goes on to say if a licensed nurse practitioner is certified. Again, this is a misstatement at best. I can show you, as I already think I have, that they have used this to subjectively determine who gets a medical certification and who does not. So with that, I will end my comments. Thank you very much.
Thank you very much. Ms. Orr?
Thank you, Madam Acting Chair and Commissioners. Again, Lindsay Orr on behalf of Delmarva Power. I'd like to start with a little bit of background and context around the Delmarva's medical certification program. Delmarva has been using the current version of the medical certification form since 2013. Prior to that time, Delmarva had a serious problem with fraud and abuse in its medical certification program. Customers were permitted to remain on the program for an indefinite period of time and were not required to make any payment towards utility services. Customers would take whatever steps necessary to present signed medical forms, including submitting plagiarized forms. The company found that the majority of the customers taking advantage of the program were customers with portable equipment such as small volume nebulizers or CPAP BiPAP machines that did not necessarily rely on electricity or natural gas in the home. These customers would run up high past due balances, sometimes running into the tens of thousands, even up to $50,000 and more, with no incentive to conserve energy or apply for assistance because the program protected them from disconnection. This unfairly increased uncollectibles for all Delmarva ratepayers. In 2012, Delmarva sought and obtained a legislative change implementing a requirement that individuals with medical certifications make a good faith payment in order to obtain recertification. In connection with the legislative change, Delmarva revised its medical certification form, adding a list of examples of medical equipment for which electricity or natural gas is medically necessary. This list was intended to be an illustration, and it was based on a list used by other utilities at that time. It excluded small volume nebulizers and CPAP BiPAP machines from the list in an effort to take emphasis away from those actual devices which Delmarva associated with the fraud and abuse in the program. However, it was always understood that any medical condition that may require the use of that equipment would not be excluded from the program as long as the form was signed by the appropriate medical professional. In other words, no one at Delmarva was making medical judgments in evaluation of the forms or entertaining any sort of subjective evaluation, to use the term that Mr. Slater used. In early 2013, once the new form and new program documents were prepared after the law was changed, the documents were provided to representatives from staff and DPA. The parties all met to discuss the various documents, and no objections were made at that time to the form. Delmarva has been using the same version of that form ever since. Now, recently, as Mr. Slater mentioned, DPA reached out to Delmarva with concerns regarding the medical certification program. Delmarva began looking into the issues raised, which involved obtaining input from several different departments in the company, including credit, customer care, regulatory, and different branches of legal, including the individuals who were involved with the legislative change and the change to the medical certification form. While we were in the midst of that review, just over a week ago, as you know, DPA filed the petition in front of you today, asking for specific changes to the certification form and to the denial letter that Delmarva sends when a form is rejected. Given the impact that this program has on all ratepayers and the number of individuals and groups throughout the company who needed to weigh in on the specific changes that the petition requested, Delmarva requested that the petition be placed on the October 9th agenda. Unfortunately, that request was rejected. We have been working diligently to gather the necessary input throughout the company on this issue, and we have evaluated DPA's requests and attempted to satisfy their concerns raised in the petition. I'll take each point in the petition, the 4 requests that are made one at a time. I'll begin with what is actually the 4th request in the petition, but the only request that involves the denial letter. The denial letter that customers receive when a certification of medical need is denied contains language directing the customer to call Delmarva if they have questions about the denial, and then if they still wish to contest the denial, to contact the Public Service Commission. DPA requests a change in this language to provide that if a customer has questions about their denial, they should call Delmarva, and that if after calling Delmarva they wish to dispute the denial, they may file a formal complaint with the Public Service Commission and may call the commission if they have questions about how to do so. Delmarva agrees to change its denial letter to provide clarity around why the customer should call the commission, but disagrees with encouraging the customer to file a formal complaint. The Public Service Commission rules encourage customers to submit an informal complaint prior to filing a formal complaint. It is in everyone's shared interest to preserve the time and resources that would be expended on a formal complaint to the extent possible by utilizing the informal complaint process. Accordingly, Delmarva agrees to amend its denial letter to state as follows. If you remain unsatisfied after speaking with Delmarva, you may make an informal complaint to Public Service Commission staff pursuant to Section 1001.2.2 of the Commission's Rules of Practice and Procedure. If you have questions on how to make an informal complaint, contact the Public Service Commission. Now, with respect to the issues involving the certification form, first, DPA requests that the phrase licensed physician, physician's assistant, or nurse practitioner, as it appears in the form, be changed to licensed physician, physician assistant, or advanced nurse practitioner. The purpose of this change is to clarify that a nurse practitioner signing the certification must be an advanced nurse practitioner. This change tracks the language in the statute, and Delmarva agrees to make this change. DPA next requests that the language in the Note to Medical Provider section of the certification form be amended to clarify the purpose of the form. Delmarva agrees to change this language to state that the purpose of the certification is to inform Delmarva Power that termination of the sale or service of electricity or natural gas to the patient will adversely affect the health or recovery of that patient. That's slightly different wording than what DPA proposed, but it tracks the language of the statute and I believe reaches the same purpose that DPA was striving to meet. The issue that is still in dispute is DPA's request that Delmarva amend the certification form to remove the examples of equipment for which electric or medical or gas is medically necessary, along with the two subsequent questions asking the name of medical equipment in use and the medical condition requiring electric or gas service. It is important for Delmarva to have a record of the types of conditions and equipment of its customers on its medical certification program for a variety of reasons. These can include storm assistance, disconnection efforts in apartment and condo settings, and a variety of other purposes. It benefits the customer for us to know this information. As I mentioned at the outset, Delmarva is not using the information that it obtains from this form to make any subjective medical judgments as to what equipment or condition actually requires electric or gas service. It is the policy of the company that as long as the customer submits a complete and accurate form signed by the appropriate medical professional, Delmarva will accept the certification. Unfortunately, I can't speak to the specific examples that Mr. Slater provided because they were not laid out in the petition or in any other correspondence to me, and I don't have the facts to discuss them, but I can tell you that it is the policy of the company to accept any certification form that is complete and accurate and signed by the appropriate medical professional, regardless of the type of equipment or the medical condition listed. Accordingly, Delmarva seeks to continue to ask about customers' medical conditions and the types of equipment that they are using. Delmarva's program includes various illnesses and is not focused on only life-sustaining equipment. That being said, it would be critically helpful to Delmarva and undoubtedly beneficial to the customers for us to know that a certain premises is running life-sustaining equipment. The statute does not prohibit Delmarva from asking for this information as long as we are not using it to make decisions on the certifications when there is an appropriate medical provider signature on the form. I note that DPA takes special issue with the exclusion in the list of examples of equipment for which electric or gas is medically necessary of small volume nebulizers or CPAP-BiPAP machines. Again, Delmarva does not make decisions about whether to grant medical certifications based on the type of equipment or medical condition the customer lists, even if that equipment is a small volume nebulizer or a CPAP-BiPAP machine, as long as the application is complete and accurate and signed by a licensed physician, physician assistant, or advanced nurse practitioner. No one at Delmarva is making decisions about what type of equipment is medically necessary or any other type of medical judgment. Delmarva is administering the medical certification program in compliance with the statute. However, as I mentioned previously, in the company's experience, customers with small volume nebulizers or CPAP-BiPAP machines were the most frequent to take advantage of the program. It is my understanding that these machines are portable devices that could be moved to a location with electricity, and the company has received reports of customers who have medical certifications but who no longer have these devices in their homes. DPA recognized in its petition the concern with Delmarva's uncollectibles. I believe DPA and Delmarva share the desire to protect ratepayers from those who seek a method to avoid paying for their usage. When customers take advantage of the medical certification program to avoid paying their utility bills, they increase Delmarva's uncollectibles that are ultimately paid by other ratepayers. The list of examples contained in the form, including the exclusionary language regarding small volume nebulizers, was Delmarva's attempt, which was approved or at least not objected to at the time, I'll say not objected to at the time by staff and DPA, was Delmarva's attempt at striking a balance between preventing people from taking advantage of the program and protecting those who truly need electric or natural gas service for their health. The list is an illustration and is not exclusive. That being said, Delmarva understands DPA's concern that customers who truly do require electric or gas service for medical reasons may be dissuaded from submitting an application because of the exclusionary language. Safety is our top priority at Delmarva, and we would never want someone whose health would be adversely affected by a termination of service to not apply for a medical certification. Accordingly, we propose to change the example of ultrasonic or electrostatic nebulizers to read large volume ultrasonic or electrostatic nebulizers and to remove the exclusionary language regarding small volume nebulizers and CPAP BiPAP machines. That way, small volume nebulizers are not included in the examples, but also are not specifically called out as an exclusion. It will remain the case, as it is today, that medical certification will still be awarded to any customer who completes the form and obtains the appropriate signature, even if the equipment used is a small volume nebulizer or CPAP BiPAP machine. It is up to the medical professional to decide whether to sign the form. For the reasons I've just stated, Delmarva respectfully requests that the Commission reject Order Number 9278. As Mr. Slater mentioned, I do have an alternative order for the Commission's consideration that sets forth the history I just described and the changes that Delmarva has agreed to make to the form and the letter. I understand that the timing, of presenting that proposed order is not ideal and apologize for that. But as I mentioned, this petition was filed just over a week ago. Our request to have it heard on October 9th was denied, and we only just determined after close of business yesterday, after attempting to confer with DPA, that we would not be able to reach a resolution before today's meeting. As the Commission deliberates here today, I would just like to reiterate that there is an extensive history here. Delmarva undertook an intensive process in 2012 and 2013 to change the legislation and its certification form to cut back on customers taking advantage of the medical certification program to reduce uncollectibles attributable to all ratepayers. And staff and DPA did not object to the use of this form at that time. Granting the petition before you today, which was filed just over a week ago, would undo all of that work with very little time to respond fully to the petition. So if the Commission is inclined to order Delmarva to remove the list of examples for which electricity or natural gas is medically necessary from its certification form, I would ask that instead of ruling today, the Commission table this issue until the next meeting on October 9th to allow an opportunity for us to gather more details about the history of the program prior to 2012 and 2013, as well as since that time, and the effect that the changes had on all ratepayers, and to give us an additional opportunity to meet and confer with DPA. The Commission rules provide 20 days to respond to a customer complaint, and most state court rules in Delaware provide 20 days to respond to any complaint. We have had just over a week to respond to this petition. I would just ask that Delmarva be given more than that to respond to such a substantial issue that affects all ratepayers. Thank you.
Thank you very much. Mr. Geddes.
Madam Acting Chair, this is a difficult place to be. As I always say, I've been around a long time, but this is it's an interesting issue. And the only guidance I can give you, to the extent you're interested in it, is I think that the timelines that Mr. Slater pointed out are troubling. I think 11.8% is a long time. I think that the severity of this is important. I think that no one should be disconnected from a machine that they need. And if we have to err, and I am a customer of Delmarva, then I would err on the basis that we don't take that chance. I would not like to be the person, customer service, that learns that because because a form wasn't properly filled out or certification didn't have all the boxes checked correctly, resulted in the death of a customer. I would think that that was a risk that no one would want to take. And I think as a commission, you have an important role in trying to determine that if we err on one side or the other, we should err on making sure that no one is disconnected from life-saving or equipment that they need. And I'm troubled that, given the recitation by the public advocate, that the company appears to be caught up in the minutia of detail because of the concern that some people take advantage of a system with portable equipment. That's a valid concern. Obviously, the cost of uncollectible accounts is borne by all ratepayers. But I would venture to say that there is no one in this room, if they're a customer of Delmarva, that would not be willing to take that risk in order to ensure that we don't have a problem that results in somebody's inability to get equipment that they need. I don't know why we're here, and I don't think it's appropriate for Delmarva to present an order to you just before the meeting. That's not fair. Not fair to you. It's not fair to, obviously, DPA. So I think you must accept, and I think Ms. Orr's comments are important. I think that those comments should have been shared with the DPA before today, before they filed their petition, so that this could get worked out. But I think the only thing you have in front of you today is the petition and the order. And if the commission decides that it wants to do something else between these two orders, I would encourage you that you make it perfectly clear to Delmarva that no one in the interim, whatever the interim is, if you don't accept or decide not to enter the order that the DPA has presented to you, that they are notice that no one is to be terminated, period, whether they have the forms filed correctly or not. Because I think the consequences of that are monumental, and I don't think this commission should be forced to make that decision today. So I think the only thing you really have before you is this petition, and staff supports it.
Thank you very much. Commissioners, can we ask if the commissioners have questions for us, please?
Well, I'd like to hear Mr. Slater.
Oh, okay.
I'll be brief. So Marva mentions cut down on abuse, and there may be abuse, but the legislature and not this commission made the determination on good faith effort to pay, and that it's approved for 120 days so long as a licensed physician, physician assistant, or advanced nurse practitioner approves it. Again, Delmarva does not have a determination to say if it's portable, you can go somewhere else, or if it's a battery, you don't need electricity to charge it. That is not within Delmarva's purview. The legislature is extremely clear on this issue. It is not something that the commission decided. It's not something Delmarva decided. The legislature decided it, and we need to comport with the law. Thank you.
May I just make one additional comment? I said this in my comments, but it seems to bear repeating. Delmarva is not making medical determinations. As long as the form is complete and is signed by a medical practitioner, regardless of what the type of equipment is that they list, Delmarva will grant the certification. So we're not saying you have a portable nebulizer, you can't have the certification. As long as the form is complete and is signed by the medical practitioner, they are permitted to be on the certification program.
Mr.
That's
Slater.
exactly what was said earlier. If you have a portable nebulizer, that you may be gaming the system, so maybe you don't need it. And so Delmarva should somehow be able to discourage those individuals. Again, the law is clear. Licensed physician, physician assistant, or advanced nurse practitioner, period. As long as they sign it, we're done. That's it.
My first question, I have several questions, but my first question for Ms. Orr is, what is the current annual usage of the program in terms of, as a percentage of, in comparison to the overall uncollectibles? And what is the dollar amount of the usage annually or monthly? And as part of that question additionally, what's the average length of time somebody uses this medical waiver?
Commissioner Drexler, I know that there are, I believe the figure is 258 customers currently on medical certifications. Unfortunately, I don't have the specific figures that you're asking for today, but I think that those are good questions and that those are the sorts of details that should be fleshed out. Mr. Geddes made the comment that all you have in front of you today is the petition and the order. This issue is, I think we will all agree, very important and deserves to have more attention paid to it than just a petition and order that was filed with you a week ago. So I would be happy to gather that information for you and provide it to the commission, and I hope that you would allow me the opportunity to do so before ruling today.
Additionally, do people have to reapply, fill out that medical form and have it signed every 120 days?
That is my understanding.
Okay, thank you. Oh, another question. How do you determine whether there's misuse by fraud or plagiarism? Do you call the doctors?
Yes, we do call the doctors when we receive a medical certification form to confirm whether they did in fact sign that form, and if they report to us that they did not, then we will reject that form for fraud. Yes.
Another question. This question is for Ms. Iori. In your petition, the footnote on page 5, you mentioned that note that the General Assembly amended section 117. You talk about the good faith effort to make payments.
Yes.
And you say, and we all, I think, agree that to this day, there's no such definition. And you say, as such, a petition may be forthcoming. Are you saying there's something in process or may be something in process?
If you'll allow Commissioner Drexler, I'll answer that question. It's my petition. But there's nothing in the process. It is that perhaps a petition may be forthcoming, given the fact that good faith effort to pay is not defined. When I had asked Delmarva Power to explain it, because there was a person that was going to be shut off based on good faith effort to pay, they did not have a definition, but they said internal was reviewing. And that's not really acceptable. And so there may be a petition forthcoming, but we have not begun that process in any stretch.
Okay, thanks. Thank you.
All right. Commissioner Correa?
As I listen to everyone with lot of details about cents and seconds and minutes and what have you, and your percentages and high amounts of uncollectible or bad debt, so to say, or late payments, and a customer who had 42 written checks of $10,000, to me, nothing became important except one thing. And we both the parties agree to that. That is a question of life. And you cannot play with people's life. Not you. No one can play with people's life. You don't want to, do you?
Of course not.
And do you also don't want to?
That is correct.
So what Mr. Geddes said is very appropriate, that let not any disconnect occur in next 15 days. If that is the request, would you to resolve this problem or this item, would you be willing to meet and come up with a solution which is agreeable to both, not for the money, not for 10,000 up or 20,000 down, but for people? Would you agree with that?
So, Commissioner Correa, I think, and I'm always happy to meet, as I think everybody has seen. The problem is that we're going to have the fundamental issue again on October 9th, because the examples and the questions are irrelevant. As is, what would the total amount be of fraud? This is again the legislative decision. I think this needs to be resolved today, and I think our petition needs to be approved today, because we cannot use the current form. That is absolutely clear. We cannot use the current form, but we're going to end up in the same position unless Delmarva removes the examples in the questions. And that was brought up on August 13th.
I have one more question though. Does the Chesapeake utility have the same kind of form?
Mr. O'Brien?
Do you have similar form, or do you use this form or the state form?
Commissioner Korea, I would need to go back and ask, I'm not aware of what form you use. I do know that on the gas side, there's much less gas service, or much fewer medical equipment that's dependent on gas service.
Commissioners, I have to point out, Bill O'Brien's not a
Not a
party to this case.
No,
We don't want to
no.
rely on anything he has to
Just
say.
information question, yes, absolutely.
Chesapeake's not either. Mr. Gray?
Chesapeake.
Thank you, Madam Acting Chair. So I tend to agree with my fellow Commissioner Correa that when we're talking about matters of life and death, I think we all know on which side we prefer to err. But I do have a couple of questions that came to my mind through the process, and Madam Chair, I'll have a motion at the end of my questions. Ms. Orr, are the DPL procedures on these matters variable by state or uniformly the same, state by state?
Commissioner Gray, I believe the statute in each state that deals with this issue, the statute that DPA provided to you is different in each state, so the forms are slightly different in each state. I believe it might be Maryland that has a commission-approved form. It's a specific form, I think, from the commission. I do know that Delmarva, Delaware's form was compiled by looking at some of the forms in our sister jurisdictions, but there are differences, I think, to some extent, based on the differences in the statutes.
So do you partition your back office in handling these kinds of forms and requests state by state, or do you have a common help set of resources that are dealing with multiple state requests?
I'm not sure what the makeup is for that, unfortunately. I can get that information and get back to you with it.
Okay, that might be an area of confusion of sorts if you've got a common unit in your back office handling a variety of different statutory requirements. What happens when the patient with the medical certification resides in the premises as a tenant and doesn't really own the meter?
It doesn't matter who the owner is. The form is for any occupant of a premises where electric or natural gas service is provided. So the name of the patient can be different than the name of the account holder.
Okay, is the PSC phone number on the current denial letter?
The PSC phone number is on the current denial letter. That was one of the issues that DPA raised. There was some confusion about what was meant by the language. DPA proposed changing it to make clear that customers should call Delmarva with any questions about why they were denied. If they wish to dispute the denial, they may file a complaint with the commission and then provides the commission phone number if they have questions about how to do so. So that's the proposed change. But yes, the commission phone number is on the denial letter.
It's on the current denial letter?
Yes.
And is there anyone at the commission who can tell me how many customer calls have been received complaining about this or these issues?
Commissioner Gray, are you saying the commission or the DPA?
Well, where I'm headed is if the phone number is on the denial letter for the commission for complaints, I'm curious to know how many of those complaints have made it to the commission.
So complaints have been switched to our office, but the commission's rules and procedures say that this would be filed, the complaints are filed with the commission. The informal complaints are filed with the commission, even though they've kind of been subsequently changed to us, which is another change that the commission will have to make at some point.
So the complaints will stream to you as a destination?
They do.
But any formal procedures would come to the commission?
That's right. If we cannot resolve the issue, then we can provide the information to file a formal complaint with the Public Service Commission staff, which then would come before you.
Okay, so you're at our doorstep today. Thank you. And so, Madam Acting Chair, and parties to this issue, the fourth paragraph in this order, number 9278, says, "The Commissioner retains the jurisdiction and authority to enter such further orders as it may deem necessary in this matter." On that basis, and I know that there may be some improvements or some agreements between the public advocate and Delmarva down the road, but today I would recommend that the Commission adopt order number 9278 as submitted.
Do we have a copy of Delmarva's form of
Yeah.
order?
I can provide copies, Your Honor.
So we haven't, so are we going to,
We've never seen it.
so are we going to have a chance to see this, or, I mean, we're sort of making a decision without seeing the change, like, without a side-by-side, it's difficult to make a decision here.
Can I
Yes.
make a point of clarification? I think that it's improper, and I also think it's impossible for you now to be faced with the idea, unless you want to take some kind of recess, and have the ability to make an informed decision. I think the only order you have before you is the one that Commissioner Gray suggests you approve. I think clearly there will be a lot of work between now and then in terms of whether that order can be modified more in accordance with some of the comments Ms. Orr made. But I do not believe it's appropriate for you to have to consider an order at a public meeting that you haven't seen before. And I think it's inappropriate, and I would suggest you not entertain that request.
Do you further recommend that we wait to, and put a cease and desist on any rejections at this point, and kicking anybody out of the program until we have a chance to see an order that everybody's agreeing on?
I believe staff's position is that we support Commissioner Gray's motion, is that this is the orders before you. You've heard the reasons to support it, and you've heard Delmarva, they've had an opportunity to comment. But I believe the only order you have before you now to consider is the one that Commissioner Gray suggested that you approve.
If I could weigh in to my fellow commissioner, I think that from listening to the public advocate, if the other party in this matter considered this to be of an urgent nature, such that they wanted to be a party to a joint and consensus solution, then there would not have been the number of days, hours, and seconds that have been presented to us. And what I'm concerned about, as this matter may take more time to resolve, is what might be the life and death consequences of someone who manages to get caught up in our proceedings.
So you move to adopt the.
I move to adopt the motions on the table to adopt 9278 as submitted.
I second it.
Any questions on the motion? All those in favor, please signify by saying aye.
Aye.
Aye. Any opposed? Any abstentions? The motion carries. Thank you. Okay, there are no hearings on the schedule. Is there any members of the public who would like to make comment?
Anyone who's a member of the public? You commented at the beginning about how the commission is now printing on two sides.
Yes.
To save paper. And I thought that you should know some other things, that I think the Delafile system, despite the struggles that have been had, has saved a tremendous amount of paper. We used to file things 7, 10 copies at a time. Documents like that thick sometimes. And that has saved a tremendous amount, and to the extent that there are struggles with it sometimes, Matt Hardigan always helps us out and helps everyone out and makes sure stuff gets filed. So that's that's a real incredible change. And then also, at least in the Delmarva cases, we've been doing, instead of providing literally banker's boxes, several at a time, to each party in rate cases or other proceedings, there's now a dedicated site you can go to look at all the documents and print off what you need. Once again, I know that in particular, I think DPA has had some complaints about that, but we try and take after Mr. Hardigan's example and try and help in any way we can. So those are tremendous changes that have happened, starting with staff's adoption of paperless filing. So you mentioned something like that to support, but I want you to know there's some really incredible things that have happened since then, and I'll continue to point out Matt, because he does, whenever there's a problem, he just takes care of it for us.
Thank you very much.
On that note, I would love to add, for the rate cases, we get a box that's about 12 by 12. It sits on my desk that's not opened, and to the extent that we can save paper, the DPA does not want a paper copy. We'll just get it electronically.
His lawyer does.
His lawyer will get it, but he himself does not.
That's the problem, but we'll check
His
on the
lawyer
X-ray
wants
case.
a paper copy.
But we do give one paper copy, so they don't have to,
Well,
you know,
instead of
gobble up
sending
their
it to him,
printers.
Send it to me.
I join with Ms. Iori's request.
We can't win.
Maybe we can let them print their own.
There you go, now you know.
Print your own.
There.
I'm happy to print mine.
All right, thank you very much. Director's comments.
Thank you,
Dr.
Madam
Malloy.
Acting Chair and Commissioners. At this time, I'd like the Artesian representative to come to the table, and staff members Lisa Drigan, Josh Bowman, and Jerry Platt. Please come up. Yes, you, Josh, you, Lisa, and you, Jerry. Thank you for stepping up. Commissioners, Madam Chair, I have 2 or 3 small items, and I'd like to go through them. I asked Artesian to step forward. There was an issue about 2 customers needing emergency services, and their CPCNs were on file. At that time, a week ago, I had to take the decision to approve them to connect the customers because they did not have water service, with the understanding that if the CPCNs were rejected by the commission, the water service would be cut off. And at this time, I'd like our Artesian representative to describe those 2 situations. And the staff members who were involved was Lisa and Josh. Thank you both.
Good afternoon, Madam Chair, Commissioners. Scott Steffen for Artesian Water Company. A couple weeks ago, maybe about 2 weeks ago, we had 2 different customers call in asking for emergency water service. Neither one of these customers were in our CPCN territory. Both situations were a little bit different. We had one customer who was on a well. Well had gone dry. It was on a Thursday afternoon, and this was a true emergency. Reached out to Lisa, see what we could do to expedite the process. Most people, most regular customers are not familiar with the 75-day waiting period to get a CPCN application approved. So obviously, in this instance, we were going to do everything we could to get the customer service. So we reached out to Lisa. She pushed through the information that we provided to Raj to get a letter drafted so that we get approval to get service out there. We connected the next day once we got the letter so that the customer could get service hooked in as a result of the dry well. Their individual application will follow the normal CPCN process, but in the meantime, they have water, which was needed, obviously. The second customer was someone building a home in Sussex County, and again, was not familiar with the CPCN rules, and they called in asking for water service, and we said it would be 3 months, typical process. That wasn't going to do. They needed to get a CO. So again, worked with Josh to get the appropriate approvals from the executive director, and we are now. They came in. We got them on the schedule. That one was not as time sensitive. There's no one living in the house right now. It's still under the construction, still under the to be approved by get the CO, I guess. So that they will get service connected this week so that they can get the certificate of occupancy. Again, this application probably wouldn't hit the PSC agenda till late October or early November, depending on timelines and meeting schedules and things of that idea. So those were the 2 scenarios. Staff did great work in helping us out, helping us get these things processed. Again, the average customer does not fully understand the timelines that we all operate in, and every once in a while we have these exceptional cases.
Who was building the house?
It was just an individual landowner. It was not a developer. The gentleman's name was...
No, I mean, was there a commercial builder who was building the house?
That I don't know. The individual's name was Benjamin and Julie Moses. I do not know who the builder was, and so, yeah, somebody dropped the ball. If you're building a house, I don't know if he was sort of doing it on his own, sort of acting as the general contractor. In any event, we didn't push for a lot of questions, because if someone calls and wants service and it seems like a reasonable request, we'll reach out to staff and get their feedback and hopefully their approval.
Madam Chair, it was in Selbyville.
Okay.
Excuse me.
It was in Selbyville. That's what I was mentioning to her.
Well, that was the Selbyville case, Benjamin and Julie Moses. The case that was in Newcastle County was a Mr. Patrick Gilchrist. Again, their well went dry, so that was a, no-brainer.
Thank you.
Thank you. Next, thank you. Well, thank you. Next, I have before you Jerry Platt, our engineer extraordinaire. Jerry's going to give you an update. That's a nice title. He's going to give you an update on the natural gas accident questions that have been raised. So, Jerry, all yours.
Thank you, Raj. I too am here to talk to you about utilities, particularly natural gas and death, as just previously discussed. What I've done is put together some comments about the natural gas explosions and fires that occurred just north of Boston on September 13th. On a daily basis, I get updates from PHMSA. They send out news articles from across the country of everything energy related that's happening. So what I've done is taken everything related to this event that I've gotten over the last couple of weeks and just compiled some brief facts for you guys to know. But I want to start with making sure everybody understands that I really don't have anything extraordinary to tell you, because this investigation is going to take a very long time. So I can give you some comments that maybe you hadn't heard just by the news sources you typically watch. If you have any questions when I'm done, I'll try to answer them, but I don't know that I'll be able to answer a lot. So with that, let me just start with my comments here. On September 13th, 2018, a series of gas explosions and fires occurred in Massachusetts towns of Lawrence, Andover, and North Andover. And this is an area just north of Boston near the New Hampshire border. There was one fatality and multiple injuries were reported. Preliminary statements indicated this was caused by an accidental overpressurization of the gas pipeline distribution system. This gas distribution system is owned by Columbia Gas. The 911 emergency center began receiving calls around 4:15 p.m. on September 13th, 2018. It has been reported there were approximately 60 to 80 fires in the three towns. When I put this together, they didn't have an exact number, and I haven't seen an exact number since then either. But it's somewhere in the order of 60 to 80 fires. The immediate response included shutting off gas and electric to the affected areas, and all the fires were put out in 2 to 3 hours, which I think that is extraordinary. In the end, gas service to approximately 8,600 customers was shut off, and these people were advised to evacuate their homes. 8,600 people had to leave their homes. In the immediate aftermath of this event, Massachusetts Governor Charlie Baker declared a state of emergency. Governor Baker was so frustrated by the response from Columbia Gas that he appointed another gas utility, Eversource Energy, to evaluate the situation and oversee the restoration of the gas distribution system in the affected area. And I want to be clear on this, because when I first heard this, I was not clear on what he had done. It made it sound as if he had shoved Columbia Gas to the side and said, Eversource, you're taking over. But that's not what happened. What he has done essentially is appointed Eversource as his liaison with Columbia Gas to report to him what's going on, and it appears as though Columbia Gas is consulting with Eversource about the steps taken to restore service, make this situation right. Although it is clearly Columbia Gas that is in charge of getting the work done and coordinating the effort. So I just want to be clear on that. Columbia Gas reports they are receiving assistance from many gas utilities and surrounding states in their efforts to restore gas service. There's a list on their website of all those that they're helping out. Gas service has been restored to many customers in the unaffected areas of the distribution system, and electric service has been restored to all areas. So at this time, most people have been told they can return to their homes, but many do not have gas service still, even though they can return to their homes. And some of these people may not have gas service for quite some time. They may go through the winter without gas service. Columbia Gas has expanded the operation of its property claims center for this event. For many years, a memorandum of understanding, an MOU, has been in place between the U.S. Department of Transportation and the National Transportation Safety Board, the NTSB, for investigating incidents of this nature, especially when a death occurs. And there was one fatality in this event. So the NTSB immediately announced that it would be taking charge of this incident investigation, and the current NTSB chairman is Robert Sumwalt. Now, at the beginning, at the very outset, NTSB announced that they estimated that they would be on site for 10 days. Well, it's been 10 days, so it's likely they have left the site by now. I don't know that for a fact, though. But they expect the final report could take as long as 2 years to prepare. It has been mentioned that Columbia Gas was in the process of replacing older cast iron pipes with new plastic pipes when the incident occurred. In a very early statement, Sumwalt, which this surprised me that he came out as early as he did making this statement, but Sumwalt said that a regulator pressure sensor line was connected to a pipeline that had been cut and capped, thereby telling the regulator to open and allow more flow. And he's putting that as one of the major causes of this event. Along with that, a Columbia Gas control room in Ohio detected a pressure surge in the system around 4 p.m. Other details were not provided, but it is obvious this is where the investigation will begin. It is reported that it appears nothing was done intentionally to cause this incident, meaning this was not a terrorist activity. It's not believed to be anything of that nature at this point. It appears to be human error more than anything. This has been a devastating gas pipeline incident, and it will not soon be forgotten. In fact, future regulations may result from the findings of this investigation, just as in the case of the San Bruno, California incident on, note the date, September 9th, 2010. Almost 8 years to the day separates these two events. So answers to our questions will not come quickly. However, what should come quickly to each of us in this room is a reminder of the extreme importance of every decision we make when it comes to a gas pipeline distribution system. This includes the operators, the commissioners, legislators, commission staff, public advocate, pipeline safety inspectors, and myself. We sometimes find ourselves debating various issues surrounding gas service, and in almost every circumstance, the subject of cost comes into play. It is incidents like this that can put cost into perspective. We have enjoyed a relatively safe atmosphere in our state, and sometimes making hard decisions is required to keep it that way. That's all the remarks I have.
Thank you very much, Jerry.
Thank you.
Thank you.
Thank you, Jerry. The next item, which segues into this, is we're going to be reapplying for the annual grant that funds the federal grant that funds Jerry's program. So we're in the process of reapplying, and just wanted to know the federal portion of the grant covers about 60% of the cost of gas line inspections, or the pipeline safety program. So just wanted you to know that. There was a calendar placed before you. You already approved it for 2019. I'm going to release it today. There's no other questions. We're also seeking approval to certify filing to the Federal FCC for Verizon Delaware LLC, which if you have any questions, my colleague Connie will be glad to answer. The next commission meeting is on October 9th. And last but not least, I need you in an executive session to get a time-sensitive approval on the artificial island FERC filing. That's all I have for now.
Thank you much. We have a motion to go into executive session. The commission may convene in executive session for the purpose of discussing legal strategy.
So moved.
Second.
Thank you.
And I'd like the DPA to stay because they are John Fowler in that motion before FERC.